Not a day goes by in which an individual under guardianship calls us asking to terminate a guardianship. Hi, I'm Darren Finley from the Probate Pro, and we're going to walk you through the process on how to file a petition for termination of the guardianship, whether you are the individual, what we call the ward, who is under guardianship, or you are another interested person interested in the well-being of the person and seeking to terminate a guardianship. The form that's used is this particular form, which is a SCAO form, a State Court Administrator Approved form, that is PC 675. It is a petition to terminate, and it can also be used for the modification. To understand the difference between those two terms, a termination brings the guardianship to an end. It ends the jurisdiction of the court over that individual. A modification is used if there is some change that is being sought, whether it is a change of who the guardian is or some other limitations or roles within that guardianship. So this is the form to use. In addition, the form has a variety of checkboxes. Included would be a termination of a guardianship for a legally incapacitated individual, as well as a minor. We're going to spend this discussion on terminating a guardianship involving an adult, the non-minor situation. So let's walk our way through it. First, you want to make certain that you identify the appropriate court, county in which this probate holds jurisdiction of the guardianship, and the case number, as well as the identifying code GA, which stands for guardianship of an adult. Next, you're going to complete the top section, which simply identifies the name of the person that is under guardianship, as well as their date of birth, race, current address. This provides the court guardian ad litem who may go out and do a visit some additional information to make sure that they are meeting and addressing the correct person. The next area indicates your relationship to that individual. Now, of course, you may be the ward yourself, or you may be a person interested in the well-being, and anybody over the age of 14 or older can file a petition to terminate and use this form, as well as the ward themselves, or really anybody interested in the well-being can advocate for that termination. Because we're dealing with an adult, this entire section under number 2 is not relevant to the termination of a guardianship of an adult petition. This relates for only a termination of a minor. Also, this section has no relevance to an adult guardianship. It relates to a member of an Indian tribe who is a minor. So let's skip beyond this particular paragraph. As we work our way to the back side of the petition to terminate, in section 3, this is an identification of all of the interested persons entitled to notice of this petition to terminate. There's a court rule, MCR 5.125, that identifies who is entitled to notice. It would include the current guardian, the ward themselves, and then other related family members. Please go to that court rule and make sure that you follow it carefully to ensure that you don't waste an entire filing or visit or hearing before the court to only learn that you failed to provide the requisite notice. There are even times that the Attorney General's office is provided notice when there are no identifiable heirs that you can serve. This section is really critical to ensure that due process is provided to the ward and all of the family members on these petitions. This next section is an identification of the why. The why you're asking the court to terminate the guardianship. And although there's only 2 lines here, you can attach as much information as necessary or provide a more verbose narrative of the basis for why you're asking to terminate the guardianship. Now, here is often where people fail to come to court with sufficient evidence to terminate. When a court has made a determination that there's a need for guardianship based on a neuropsych report or medical providers, we really urge people to seek an opinion from a physician to support the petition to terminate. Because often if you go to court on these petitions and you don't have sufficient medical evidence to counter what was the basis for the guardianship, you've gone to court and then the court may order subsequent independent testing or yourself to go get a physician statement to support the basis for the termination. Now, it is not a requirement, but we urge you to consider that as a factor before you go and put all this energy into filing a petition to terminate. So cite a basis. Why is there no longer a need for the guardianship? The person's improved in their health, they're functioning in a manner that no longer requires it. If you've got questions about this particular aspect, it's really critical that you consult with a competent, experienced lawyer in this particular space. This next area is the request part. This is what you're asking the court to do. If the court were to grant your petition, you're going to ask the court, of course, here to terminate the guardianship, and then some of the other provisions here speak about the modification provisions in the event that you were asking rather than terminating, but rather to modify who the guardian is. So remember, the filing of the petition is really step one. This then gets scheduled for a court hearing. The court may appoint a guardian ad litem. The court may appoint an attorney for the ward under certain rules. And then there's a hearing in front of the probate judge of which the party or parties get to advocate and argue their relative positions. So it's important that, again, you fill out this section with great attention to clarity that you're asking to terminate the guardian. The next section is important because then on any of these forms, you're declaring under the penalties of perjury that you've examined it and that the information contained within it are true to the best of your information, knowledge, and belief. So it's a penalty of perjury clause, and before you sign an important legal document, make sure you've thought about the contents and that you're confident in standing behind those assertions that you've made within the pleadings themselves. Here, the petitioner is the party that is signing the document, and if there's a lawyer, the lawyer would also sign it. Now, again, I'm trying to give you as much information as possible to help you navigate your way through these termination proceedings where you're asking the court to end a guardianship. But if you need assistance and you want a lawyer to be there with you through this process, you're welcome to call us at 877-YOUR-FIRM or visit us at theprobatepro.com. We're also happy to provide you a link to these forms so that you can go and file them on your own if necessary.